Trial Lawyers University, where the Titans come to train. Produced and powered by LawPods.
Well, hello, everybody. We're here with the legendary David Ball. And David and I have been knowing each other a while. So we kind of met in the pandemic through our friend Sean Clegg and did quite a few programs on various topics. I remember one on nuclear verdicts that you and Sean did a couple sessions of it. That's on TLU On Demand and highly watched because it's only a year and a half old, so it's still highly relevant. David, how you doing today?
I'm doing pretty good. How are you doing? You look good.
I'm living the dream over here. I've got finishing my dojo here in Vegas. They're coming over to start working on it.
Yes, that's pretty impressive. That's pretty impressive.
Well, when you see the other half, because I'm putting a studio in the other half.
Yeah, but is the other half a corner dojo, like light from two sides like that? That's beautiful.
No, but it will be connected to this one. So it will be by relation. So I'm looking forward to that. Hopefully we've done it in a couple months.
Great.
And David, you missed the greatest trial lawyers event we ever did 2 weeks ago in Huntington Beach, California. There's about 600 people there. We rented out the whole hotel. We had the greatest list of trial lawyers coming, but we'll get you on there next year because you know what? You're very valuable on Zoom.
That is target area for the tsunami whenever it shows up. If I get blown away in a tsunami, do I really want it to be, with a bunch of lawyers? No, I want it to be with those 78 virgins.
Fair enough. That'd be very appropriate. Very appropriate.
At this age, it would do nothing.
Right. But the good news is we already have Huntington Beach booked for June 4th through 7th next year. So we could get that on your dance card. Because we know you're coming to Vegas this year with Artemis. And your appearance will only be by Zoom, but Artemis will be live. So she could be the better half of you in person.
Also doing a session with, which should be really pretty incredible, with Dorothy Sims.
Yes, and we're going to talk about that.
She and I will be meeting about this next week. Both of us are heavily involved in science and experts and all the BS that we have to contend to and how to blow those people out of the water. It'll be stuff that anybody who ever uses an expert will really want to hear. I don't know if they want to hear my part of it, but they'll definitely want to hear what Dorothy has to say.
Yep, and we're going to talk about that in a little bit because first, I know you used to be, or you still direct and you're still heavily involved in theater, but I want you to give us a little bit of an idea how you went from, your career, from being in the theater and getting all that experience in the theater and then kind of transitioning all that stuff that you learned and did into being one of the, foremost trial consultants, if not the foremost trial consultant, and really wrote the first major book for plaintiffs, damages and the various editions of it. And I know that wasn't your first book having to do with trial, but still most likely your most popular one. So kind of give us the backstory of how you got into this.
Well, it actually started when I went off to college. To start with, I went to science and engineering, a place called Rensselaer, RPI, and because I was going to be an engineer. And I found out engineering was interesting, but I really loved the pure sciences. And I thought, of the pure sciences, the one I love the most is physics. So I go marching into the dean's office one day and I said, Dean, I'd like to change my major from electrical engineer. This is after about a year and a half there, so I was well into it. I'd like to change from being an electrical engineer to being a physicist. And he looks me in the eye, probably the most important thing anyone ever said to me, and says, Mr. Ball, there are no B- physicists. And I thought, what do you have to be? He said, you have to be an A+ if you want to do anything interesting in physics. Otherwise, you can get a job, but you won't be really doing. So I kicked that around. And he said, there's nothing wrong with staying with physics for the rest of your life, which I have, but you might want to think in other directions. So that's when I did what everybody did at the time. What else should I do where I could make a living? So I left the engineering thing, went off to the liberal arts college in Western New York, a place called Alfred University. I just thought the name was funny. Turned out to be a very nice little place. And somehow got involved in theater, very involved in it. And that became the focus of what I did. I eventually did a master's degree in English, which is one of the more useless but interesting degrees you can get. But I was still always involved in the theater. And then I started graduate school in theater. And what we were forced to do, thank God, because I didn't want to do it, was theater and communications. And you had to pick a specialty within communications. And the least obnoxious one seemed to me to be small group communications. I had no idea I was ever going to use any of that stuff, but it turned out to be enormously useful because what the dynamics of a small group like a jury are extremely important. You can take a group of 12 people, change 2 or 3 of them out and put 2 or 3 other new ones in there, and it will totally alter what that group of 12 does when they come up with a conclusion, whether that's a working group or a jury or almost anything else, brainstorming session. And at the time I thought, well, it's all very interesting, but I'm an artiste. I don't need that crap. And, here we are. It turned out to be one of the more useful things. The science and the methods of research that I learned at Rensselaer have proved incredibly invaluable because so much of what I do depends on science, whether it's working with experts or working against defense experts. The more I got into it, the more I was able to bring what I knew about the sciences, about what constitutes, how do you get to a conclusion with some scientific validity. Along the way came the gifts of Daubert and Fry, which if used properly get very powerful. But at the same time, I had the luck of all those years in theater, and I had a very lucky theater career. I went to the University of Minnesota, which was sort of the only good place to get a PhD at the time. I had a master's degree in English at that point, and I thought the only thing in the world more useless than another master's degree in English would be a PhD in theater, so naturally I went for it. But I was very lucky. I ended up on the senior staff of a place in Minnesota called the Guthrie Theater, which at the time was probably the major theater in the hemisphere, is still a theater of very high stature. I learned an enormous amount there.
So, David, let me ask you, though. I know you had some moves from Guthrie, but how did you first get started in theater? Was it in grade school, high school?
Well, I went to this, like I say, it was lucky. I went to the University of Minnesota to get a PhD. They had at the University of Minnesota a wonderful fellowship program. It still exists, but under a different name. Then it was called the McKnight Fellowship. Minnesota Mining just gave a ton of money every year to support 8 or 10 grad students every year. And you would spend a year or a year and a half at the University of Minnesota, and then you got a season at the Guthrie. And if you were good, your season became 2 seasons, 4 seasons, 5 seasons, 10 seasons. And a small group of us in my year were there for a huge amount of time. And then everybody went on to have wonderful careers because the credit from the Guthrie at the time was like a passport to almost anything else you wanted to do. It eventually ended me, the others were actors and scene designers, and mine was in playwriting. But I got very heavily involved at the Guthrie in directing. Directing incorporates an enormous amount of strategy, of understanding the analogy, understanding the facts of a case, or understanding the script that the playwright has created is almost exactly the same process. And the way you analyze a script and the way you analyze a case gets very, very close. And of course, there's the whole performance, who the actor is and for who the trial lawyer is. That's all in common. But there was not much of a leap. I went from the university to the Guthrie, and suddenly I found myself at the top of the profession. I did not deserve it at that point. I was, 25, 30 years old. I was 27, 28 when I got to the Guthrie. But when you're surrounded, the guy I worked with in the next office was considered the best director in the English-speaking theater. And I was working closely with him every single day. And the amount you learn that gets you well past your own maturity and wisdom and knowledge in 6 or 7 or 8 years of doing that is beyond belief. Just as some lawyers have lucked out by getting a job out of law school into a firm with, just an incredible trial lawyer who's mentoring them. I had that same piece of luck. And I went from there to teach temporarily at a lovely little school in Wisconsin called Lawrence University, fell in love with teaching, and ended up at Carnegie Mellon University's Theater Conservatory, which at the time, still is really one of the top 2 or 3 places that people who want to go into the professional theater or film go to learn how to act, how to write, how to direct, how to produce, all that stuff.
Wait, how long did you spend at Carnegie Mellon?
I was at Carnegie for, I don't know, 7 or 8 years, I guess. And I finally decided it was time for me to see if I could run things on my own instead of just being on the faculty and working for other people. And I came to Duke to develop their theater department. And I learned that, yes, I could develop it. It very quickly became the go-to place among liberal arts universities theater. I built this incredible little faculty. And at the same time, I learned that I hate administration. I hate academic administration. So it was a good lesson for me. And I also, by then, I'd been doing theater for a good long time. And I suddenly got, and this will go back and answer your original question, how the hell I got into this business. I got very tired, partly from hating the academic administration, but also I had directed by then, I don't know, I was directing 3 or 4 or 5 plays a year for, 15, 20 years. I ran my own theater along the way. When I was at Carnegie on the side, we had a little professional theater that I ran. So I just got to the point where I did not want to ever direct another play, and I stopped. In fact, did not direct anymore until right now, 30 some years later, when I'm directing something. And instead, I fortunately had enough resources that I was able to go off in the woods and write. And I thought, I'll write the great American novel. And I did, except I'm the only one who thinks that. So
Wait, hold on.
if anybody wants to read
What was the novel about? This great American novel that you wrote that nobody's read except you.
It's actually out there, and it's actually now been optioned for a film. It's called The Swamp Outlaws. It's about a group of Lumbee Indians in the swamps of North Carolina during the Civil War, and how they survived there, and how Henry Berry Lowry, who is a Lumbee Indian, was legendary at the time. He was so legendary that the Jesse James gang would sometimes pretend to be Henry Berry Lowry on a raid to scare people to death. And Lowry became the highest bountied outlaw in the history of the country up till that point. And he's still a legend for the Lumbee people who still are in that part of North Carolina. It was a fascinating story, and I told it from the point of view of an outside, non-Indian, Native American journalist from New York who came down to do a story and stayed, so that I could do it from the point of view of me as an outsider, which is exactly what I was. And that was what it was about. I don't know when I say it's been optioned, everything can get optioned and never get made. I think 5% of things optioned. But, there's enough interest in the damn thing. And it sells now and again. It goes through little peaks of sales on Amazon and that sort of thing.
Well, maybe this podcast will give it a boost, because I think a lot of people didn't know.
It might. A number of lawyers have read it. One lawyer was reading it with his wife on the beach, and they're both sitting there in the scantiest beach clothes you've ever seen, and they're both reading copies of Swamp Outlaw. I thought, well, there's something I should put on my wall. So yeah, I remain very fond of that book. I think it has a lot to say about today, because that time and this time are very similar. It certainly does get into the feelings that this separation of the races, not just black and white, but black, white, Native American, what that mixture was doing, and how the people on the bottom survived. That was the novel. However, I was writing that novel off in a lovely little cabin I had in the woods about half-hour drive out of where I am here in Durham, North Carolina. And I realized what I had really loved about theater, other than it's an art form that's very fulfilling, is that it's your family life, it's your love life, it's your social life, it's your passion, that is your entire world. And the thing all those things have in common is it's all full of people. You are never alone, which I guess I loved, because there I am out in the woods. Writing is a very lonely sport. And I thought, my God, I'm going crazy out here. And I started thinking, well, I can go to the grocery store, but you can only shop for groceries. So just to be around human beings instead of looking out your window at this beautiful North Carolina woods with no one there except a cow. So I started going back to something I'd always been interested in. I started hanging out in the courthouse in Durham. And I would write at night, but during the day I started watching trials. And I watched trials for a couple of years, a year and a half maybe. But I mean, I would watch the whole thing beginning to end. I was really puzzled why something that should be so inherently interesting, because it was about conflict. When you looked at the jurors, they were all and always bored to death, except very rarely. You could walk in the room, and if you didn't know better, you'd think they'd all died in place. So I started, just out of curiosity, looking into this, and a lawyer that I'd met over the year and a half of Washington said, why don't you write an article about it? People are always saying trials are like theater, but a top-level theater professional has not written anything about that. Write an article, get it published in the state thing, the state trial. So I did that, and then I start getting calls, will you come help me with my case? And I said, no. I don't know anything about what you guys do except what I watch. And so one fellow called me and says, listen, I teach a trial advocacy course over at UNC, or there are courses like that. Go sit in on one of those courses for a semester or two and get yourself started. And I did. A brilliant teacher named Charles Beckton, who top-level lawyer, teaching a wonderful course. So that sort of got me very interested in it. And I did my homework and learned all about how the development of trials and the development of theater were intertwined at the beginning, that you wouldn't have had one without the other. The same people were doing both at the same place at the same time and for the same purpose, which was to persuade the population of something. I was off and running. That's how I got involved in this. I didn't want to go back and direct plays. I didn't want to do theater anymore. I certainly didn't want to do any more academic administration. And I'm not so sure the academics wanted me to go back and do any more academic. I would win all the battles, and by the time I was finished winning all the battles, everyone hated me. Think Douglas MacArthur, not Dwight Eisenhower, although not on that level. So I come to trial consulting from the point of view of the only real expertise I had that I thought of at the time was I know audiences. One of my jobs at the Guthrie had been to watch performances every night. It was a repertory company. One night it'd be one play, the next night a different play, the night after that a third play. So over the course of a season's run, things could start to wobble unless I kept a close eye on them and would, talk to the actors and put things back in sequence the way they were supposed to be. But that comes from watching audiences with your whole interest on how is the audience reacting, just like how is the jury reacting, to what is being put in front of them. And I started hanging out in the lobby, first talking to people, then just sort of sidling up and listening to their conversations during intermissions and learning how they were reacting to what they had seen. And that was probably the strongest stuff that I had at the beginning. How do we turn this boring, monotonous thing into something they will pay close attention to? That was sort of phase one. And that was maybe the first couple of years I was doing this. That in itself, it's solid gold for doing trials, because I could listen to an opening and say to the lawyer, they're not going to have any idea what this case is about by the time you sit down at the end of your opening. Here's how to do it instead. So that's how that started.
Let me ask you, because it's, you got Artemis is your partner. And so tell us how you came about, how that relationship and this business partnership came about.
Again, it was luck, just like my ending up in that fellowship for the Guthrie. I was, I don't know, maybe 10 years into doing this stuff, a little bit less, 7 or 8 years. But the books had gotten me a fair amount of repute. At Duke in the law school was a very high-level jury research scientist. Not a consultant, although he did some consulting, but he was one of the very few, just a handful. There's a ton of people that study jurors, and most of them are a waste of time. He's one of the handful, at least in my opinion, who did very high-level, very useful work, things you could learn about jurors and how they responded to things. Artemis was at the law school, and I forget if she was in L2 or L3 at the time. She had fallen in love with trials, but She didn't want to do trials for a variety of reasons. The most important thing is when she starts talking about how somebody has been hurt, it's very hard for her to maintain control of her emotions. And she would have gotten past that like other people do, but she didn't want to. But she did want to be involved in trials. So she was talking to this researcher I was talking about. His name is Neil Vidmar. And Neil suggested that she come talk to me because he knew that I'd been consulting. And then he knew that I was, at the time, the only trial consultant in North Carolina and still one of not that many nationally. This is slightly after the OJ case where the explosion of trial consultants happened, but not that long. And she came and she interned with me for a year or two. And I don't remember the transition intern into just doing this stuff. And I realized this is an unusually brilliant person with great insight, empathy, perception of how other people react and behave. Smart. I mean, my rule, if you're going to hire somebody, make sure they're smarter than you, because otherwise, what good are they to you? She was just about perfect in any way. And she's nicer than me. People liked her more than they'll ever like me.
You did set the bar pretty low, so.
I set the bar very low. But nonetheless, people really liked, and today really love Artemis. And she learns like a sponge soaks up water. And then she takes what she's learned and she turns that, makes it around, she goes on, and I can't say too much about her. So it was really just a matter of luck. Neil could have sent somebody different. It might not have been as good a law school at Duke. It might not have been somebody as incredible as Artemis. I had nothing to do with his selection. The only thing I said is, I'm not letting her go anyplace. It was not hard to keep her around because she loved the work. And she's, to this day, as I've been cutting back on how much consulting I'm doing, because 82, this day after tomorrow as of the day we're recording this, I've been cutting way back, and she's stepping up, and people get more for their money when they get her than when they get me, because she knows almost everything I know. Plus, there's more of a human element in what she does than I really bring to it ultimately. She's now learning from other researchers and consultants in a younger age range. So this is sort of she's one of the handful that's at the lead of the new generation of folks that's coming along. And I find that extremely exciting to watch.
I bet. Now, you've written quite a few books. Now, your first book was called what? Theater and Trial?
It was called Theater Tips and Strategies for Jury Trials.
But that wasn't the one that put you on the map.
It started.
What was the impetus for that first book?
When you get started, and when you really get started as a consultant, every consultant's worst problem, I suppose like any attorney's problem if they don't get hired by a law firm, is how do I get people to know who I am? I wrote a series of articles for a publication called North Carolina Trial Weekly. I think that's what it was. Yeah, there's an equivalent in almost every state. And they sort of gave me a column. So every month I wrote some little tip, I don't know, a 500,000, 2,000 word article on how to do this in voir dire, how to do that, why you should do this, and all that sort of thing. And it was monthly, and I wrote a bunch of those. And then I realized that only helps in North Carolina. It was very hard. I was getting hired plenty in North Carolina now. But how do you get hired? You can't just depend on one state because so few people at the time were hiring trial consultants. You needed more business than that. I had a friend who was in the same position in Colorado at the time. She was just getting started. People don't like to hire you if you're local, except that was all we were getting. So you get a little bit of local work, but then they're always looking afield for somebody else, not you. So she and I were going to change addresses. We were going to pretend that I lived in Denver and she lived in Durham. And so because you step off the plane, they think you're smarter. But in any case, the way I finally solved that problem, instead of changing addresses with her, Mary Ryan was her name. I'm not sure if she's still being a consultant, but she was brilliant. I taught with her a number of times. Was to write a book, get somebody to publish it. I didn't think anybody would because not many strategy books were out there that day. So I sent it off to NITA and the National Institute for Trial Advocacy, and they said yes, and they published the thing. And I thought, oh, okay. Yes. And that's really what got me invitations to teach at the major seminars around the country, which were just getting started at the time, which was great because I love teaching, but it also put me in contact with a number of the top lawyers. And I'm sure I learned more at all those seminars than I ever taught. And it was a number of years of them. And then the real kick, the thing that thank the Lord put me on the map. And again, it was luck. I always used to tell my theater students, you work your ass off to prepare yourself so that when the break comes, you're capable of taking advantage of it. A lawyer is the same thing. You have got to prepare for your next case, which may be a trivial little one of your first cases, as if it's going to be the most important case anybody's ever done, because you never know when that's going to come along. And if you blow it, you may not get another one. It's not true. I don't want to scare people off of that. But it is true that if you do well, you're off and running. And if you do twice in a row, you're real. So a break comes along. I get an invitation to teach how do you get damages from juries, which today you can go online and find 5,000 things about. If you went, not online then, I don't think there was much online, but I really did my homework. I asked everyone I knew. I went through every publisher, every article, every TLA, the Trial Lawyer Association, everything. There was nothing in print about the strategy of damages. There was one very good book that dealt mostly with the law, but there was nothing really about damages, and certainly nothing that was taking advantage of what we were starting to learn about how jurors make decisions, learned from the neurosciences and not from 20th century psychology. And I thought, that's a niche. It's empty niche. I know evolution and the theories of evolution very well. You move into an empty niche and you do okay, and you will survive and flourish. So when I sent the book to the publisher, I had very little doubt they would publish it. I was pretty sure they would. And I wanted to call it David Ball on Damages. And they said, wait a minute. Hardly anyone knows who David Ball is. Why not just call it Damages? Nobody knows David Ball. I said, they will. Put my name there and they will know who I am and the name will sell books. And it was a lucky choice. It was a bullseye. And that's exactly what happened. And over the years, that damages approach has obviously grown a whole lot. Till today, we have such a world of knowledge from what the neuroscientists and others, including some very good consultants and researchers out there, have been gathering that this is now an amazing set of tools. And I'll be covering some of those in the October session in Las Vegas. So I did a couple of more editions over the years of damages.
Right. So
the most recent.
So there was damages, and then there's damages 2, and then there's damages 3, correct?
Damages 3, and they're all very different. I am not a fan of putting out a new edition unless it's worth everybody's money and time.
Just give us
to invest in that new book.
Some concept of clarity and timing about how much time was between damages and damages 2.
Damages 1 and 2 were not that far apart, a few years, partly because my learning curve was skyrocketing, because now I wasn't just studying to write a book. I was now Mr. Damages undeservedly in the eyes of many people. I thought, well, you better have the product if you're advertising the product. So my learning curve was very rapid. It was a little longer, and right after we got into Reptile was when I did Damages 3, because Reptile, the fundamental concepts of Reptile really changed everything permanently in the field. I mean, people today still are using Reptile without even realizing that's what they were doing. It had an incredible effect, partly because Reptile is so closely related to the purpose of the courts, the purpose of civil plaintiffs stuff is part of the fundamental public policy of it. So
what do you mean by that, though? So because not
well, the purpose of compensation is not just to make the client whole. The other purpose, and in the eyes of many the more important purpose, is to discourage future bad conduct from the defendant and others. And I'll never forget the day I first taught that concept, what I just said, the part of the purpose, major part of the purpose, a major part, is not just to make the client whole, but to deter future bad conduct on the part of the defendant and others. When I first taught that was the first time I taught in front of an audience, maybe 150 people there, and almost every one of them looked up as if I was crazy. Boy, you don't know the law. And I mean, really, it was not abusive because we all liked each other, but it was horrible. And I'm thinking, they went to law school. Why don't they know this stuff? And of course, it is absolutely true that initially at the beginning and explicitly today, part of the purpose of compensating an injured person is to discourage other negligent or whatever the tort is, from doing it again or from other people doing it. Whether you can argue that explicitly, you almost always can, but there are places where you can't. But you can build that concept into how you frame the case. That's fundamental Reptile. I can go into that further if you want, if we get to that point. But that's where that started. And then something came along that made it the actual concept of the supposedly reptilian part of the brain, which isn't really an area of the brain. It's just a complex of stuff in the brain that's there no matter where you place it in the brain, which has to do with survival and safety and survival of your genes and the power of being driven to make decisions that are good for you, what's in it for me, sort of thing. How do we do all that without running afoul of the rules and the law and all that? That was Reptile. So even though the Reptile book is not on the market anymore, you can buy a copy for about $2,000 or $1,000, depending on the week, on Amazon. There's pirated copies there. So if you have a copy you want to sell, you can probably get at least $800 or $1,000 for it on Amazon. And it's a short book. You can Xerox it and sell your copy. But the fundamentals of it are in Damages 3. Neither the other people who worked on it with me nor I refer to it as Reptile anymore because we had all decided to sort of go our own separate ways. We worked with each other for a long time, and that was plenty. So we just stopped using that word, but the concept did not change. And both of us, those of us who worked on it, we sort of developed it on our own very unique ways.
Right, because it was you, Don Keenan, Gary Johnson, and Jim Fitzpatrick. Is that right? So,
and also Rick Friedman was involved.
Okay, and so how did you?
Rick Friedman.
I don't think Rick got any credit on the book.
It's on the cover. He's on the cover of the book.
I got to check. Okay,
on the cover of the book is one of the researchers.
Right.
He came to. He made a few cross-country trips to come to research. We did the research all over the country, and he came out to. I remember him. He was in Kentucky. Met someplace here in the South. Anyway, we met. That's how I got to know Rick, actually.
But how did
we become friends?
Whose idea was Reptile to write this book and then
It goes back to a marketing guru named Clotaire Rappai, Rapaille. He wrote a book called The Culture Code, and some of his ideas transferred directly to what we need to do with a jury, not by being salespeople about it, but the fundamental things of how people decide to buy one kind of coffee instead of another kind of coffee. And if we had time, I would walk you through some of his research conclusions about how he turned a not very well selling coffee into the nation's #1 coffee almost overnight by what he had learned in the kind of research he was doing. So we started applying that same sort of research to the kinds of issues we face in trial and found out that it was almost foolproof, to the point where today, and I'm sure most people listening to this will be familiar with this, if you go to trial with most cases, you'll get a motion. You will get a motion from the defense that says, Judge, don't let these people use any Reptile stuff. Or my favorite one is, don't let them use any David Ball stuff. A lot of them says, keep Keenan and Ball out of this. And the judges, unless you know absolutely nothing about how to handle those motions, and there's plenty of help available, you'll win the motion. That's not an issue. But I love it. I mean, there's stacks of these things around, and I probably have the unique position of my name is used in more motions to keep you from doing something than anybody in the world, except maybe Don Keenan. He's there with me. Ironically, none of those motions, or hardly any of those motions, ever are granted. But that's the level of how much the defense feared that. A number of consultants made a living for a number of years by teaching how to defeat the reptile. Interestingly, because none of them ever did. They never managed to, because it's that kind of almost ironclad thing that if you do it well, and if you build it into the best of what you already do, I don't want to say it's hard to lose, but your chances of winning and winning very solid verdicts skyrockets. It really maximizes whatever you're capable of, because it gives jurors a reason to want the case to come out your way. And that reason is partly justice, but what's the reason they want justice to be done to our client? What's in it for me, without violating the golden rule, without even coming near the golden rule? And it took a little while to develop that, a lot of research. I mean, a weird kind of set of focus groups that we never recommended people do on their own unless they really learn how to do them well, in which case they're great. And the resources from that are enormous. As I say, still affects things today. We just don't use that word, which is why the Reptile book is no longer there. But the concepts are there to be learned if people look for them. And I probably will be teaching some of that. I don't want to spend a ton of time on that. I'll be teaching some of that in October at the TLU.
And you started out and you talked about trial consulting and building the trial consulting, basically industry. You're really the first trial consultant I think that most people have heard of. And you said I think you told us you really dialed back the amount of consulting you do these days. But I know that Artemis does quite a bit. In fact, I just got off a webinar prep session with a couple lawyers from DC, Kieran Murphy and Katie Bertrand, I think. But they have a webinar coming up on a great med mal verdict they got that Artemis consulted on. And Katie was just glowing about Artemis, how insightful and wise and all these things. And so
It's true.
But so
whenever Artemis and I are consulting, and we do a lot of this together. Still, even now, we do a lot of it together. She does, all the focus groups and all the jury selections, but we'll do the early strategy things and the late strategy, by Zoom. If she and I disagree about something, we'll discuss back and forth, and I know to start with that she will turn out to be right. I'm not sure how to express this. I am very, very smart. So is she. She is wise. And that's something I had in the theater, but I don't have that level of it like she has in this business. And I'm people oriented. She's much more human being oriented. Empathy is an extremely important topic. I'll be covering that. And we'll talk more about that later. Yeah, she's pretty remarkable. When we consult, I decided right from the beginning, I look around at the few consultants that were there, and every case that a consultant worked on was enormous. They were putting in 50 and 100 hours, the few consultants that were out there at the time. There weren't few, there may be a few hundred across the country, of which maybe a couple dozen were any good, but they were good. But that had to be enormously lucrative, potentially large cases or criminal defense with huge amounts of money before a consultant would walk into the case. I decided I can help a case in an hour or two, but I also want to be involved in cases where I'm involved all the way through. It's two different kinds of work. To this day, I still do a lot of work where somebody will be on the phone with me for an hour or two. So, that's affordable. They can do that. And it doesn't have to be the hugest case in the world. And also, we've been explaining to people, if you're talking with me about strategizing a particular case, that becomes part of your costs for the case. And in fact, it can become part of your costs if it's a more general kind of thing. How do you do civil rights cases in educational settings, for example? They can amortize that over a certain number. In other words, I always try to make it really, really accessible, while at the same time, if the case called for it and the resources were there, putting in the 50, 100, 200, 300, or whatever hours it was. And that's been very important for me, because the more different kinds of cases I can consult on, the more I learn. So if you come to me and say, have you ever done such and such a kind of case before? That hour of consulting that I might have done probably involved a lot of prep time that I didn't charge for. Because I figured if I've never done a X kind of case, whatever that is, before, I'm not going to bill you for my learning time. What are the general dynamics of a sexual assault case in a church? That you need to know a lot of stuff before you get involved in that. Well, I should know that as the consultant. I'm not going to charge you for it. So the more different kinds of cases. So if you come to me and say, I've got such and such a kind of case, it's very, very rare that I'll say, no, I've never done that. Or most of the time by now. And it's one of the advantages to any good consultant. They have done more cases and gotten more intimately familiar with juries and how they operate and how they resolve than any lawyer ever can do. Lawyers, the key difference between a good consultant and a really good consultant and a really good trial attorney is consultants have the time to do the research into the science, and they have the time to really study juries. Somebody like Artemis has got both an intellectual knowledge and a feel for juries that probably surpasses anyone I know. I'm sure there are others like that just among the world of people that I know. And lawyers don't have what do you see of jurors? You get up, you see them when you see them react as you talk and work with them, but you never really get to sit down and talk with them for very long. Sometimes you get to talk with them after trial, but you're no longer a neutral person to them. So you're not really going to, in any case, the good consultant knows, and I said before when I started, there are maybe a dozen or two good ones. There are a lot more than that now. Not as many more as I would like, because so many people just hang up a shingle just like, anybody fresh out of law school. But there are a number of really good ones. You've met some of the good ones, I know, because I've seen them on your roster, whose viewpoint of things. Look, if you're going to hire a person to bring in a medical opinion, because you're not a physician, or whatever opinion, the consultant is your jury expert, literally. They not just jury, they strategize, because their strategy is all aimed at the jury, and they strategize in a way that lawyers can't do, because rarely can do. It was also the consulting field, I think, that by and large got lawyers to see that you have to do focus groups. So I've always put a huge emphasis on teaching people how to do focus groups when they have very few resources to do them. And sure, you got people who never read a book. You've got one consultant who goes around telling people not to read books. That's just, silly. But then you've got this great number of lawyers out there right now who's doing what they go to TLU stuff. They get everything they can from you, from the other good seminars out there. They read, look at Trial Guide's shelf, which is mainly lawyers, but some consultants. But when you get right down to it, the ability of a consultant to add a level, I've never heard a lawyer say that they did not learn something totally unexpected and critical in their focus groups, if the focus groups are well done. But again, we work on cases without focus groups, and the resources aren't there to do them. We teach you how to do some stuff on your own.
And at TLU in Las Vegas, we have quite the lineup of trial consultants coming. We're going to have John and Alicia Campbell, and they do the big data research that people.
John is, I don't know Alicia. I haven't met or talked to Alicia. I've spoken with John a couple of times. And yes, I think he has been one of the pioneers of an extremely important field. It does not replace, you still have to do your focus groups, but that big data, when responsibly run. But I urge people, and I'm sure John does too, be careful. Any fool who's had a year of statistics can call themselves an expert who can go online and do the John Campbell stuff. They can't. Campbell can, there's others who can.
Well, besides the Campbells, because they just released the book Jury Ball with our mutual friend Sean Claggett. And
I'm glad they put my name in the title.
I know. I thought that you would like that, and so it was a very hot selling book.
My name. There was a show on television called Dr. Bull, right? And everybody said, "That's David," and I said, "No, it's not." And so I got into this thing of saying, David Ball and Dr. Bull deny each other's existence. So there you are. But Jury Ball, yeah, I like that title. Jury Watch, which is the name of my company. Jury Ball, obviously named in my honor,
Obviously.
don't you think? Don't ask them. I haven't seen their book, though. I probably know much of what it says by now.
So that way, here it is. This is the Jerry Ball book.
Who's the publisher? Oh, look, my name is in red. Who publishes that?
I think it's a self-published book because they want to keep control over the distribution, and and they have.
Yeah, that's fine. All the Reptile books are self-published.
Yeah. So besides,
Look, the best book I know of on small cases is a book called Reptile in the Mist, which is simply a collection of articles by people who knew how to do the reptile in soft injury cases. Yeah, that was self-published. All the Reptile books are self-published.
right? Because besides the Campbells, and besides Artemis, we got Sonia Chopra from Los Angeles, who works a lot with Brian
First rate.
Panish. Harry
rate.
Plotkin from Los Angeles.
Plotkin is very good. He is. I keep hearing people rave about his
Yeah,
work.
he's been involved a lot. Eric Oliver, who's now out of Chicago.
Eric was one of the few who was there before I was.
Wow, that's old. Wow. I'm going to have to call him out on that.
Eric is one of the smartest people I've ever met. There's a lawyer in Virginia named Chuck Zauzik who might be that smart, but he is brilliant. And when he works on a case, he makes you see things that nobody else, not me, not Plotkin, not nobody, would ever see. He's amazing. That said, he's also a very good friend. So, yes, I'm playing favorites here, but the brilliance of there are a lot of people I'm friends with who are good consultants, but not on that level. He's difficult to read. His books are hard to read. I suggest you still take the trouble to do it. But when he's working on a case, he's as clear as a frickin' bell.
And then we're not done yet. We got Jesse Wilson because he wrote this book.
Jesse is more or less of a newcomer. I'm very excited about him.
Right, because he's got his.
Jesse is.
He's very active in teaching.
Yeah, and read his damn book. Read his book. If you don't have Jesse's book, I don't know. It's Trial Guy's book with his name on it.
Yes.
Telling the story or something like, I don't know what it is, but
telling the winning story by Trial Guys.
Yes. Rick Friedman has written the best books out there across the board. I tell people if Rick wrote it, you've got to read it. Jesse's is one of the few that I put up in that category. There are a lot of really good books out there, and you have to be selective. Nobody can read them all, but that's one of the central ones. I don't like to recommend books a whole lot because people then who wrote books who are friends of mine, I didn't mention their book, I'll get mad at me. But I'll make an exception for that with Jesse's book because it's remarkable.
And then finally, Sari de la Motte is coming. She wrote the book. What's the name of her book? It's a very popular.
I have no idea.
It's called. Sometimes I have these brain freezes. I've seen it a million times. But anyways, I'm very excited to have her come because so many people at Trial Lawyers University, like Jay Vaughn, there's so many people that have used her and worked with her and just so excited about her materials. And this will be her first time appearing at Trial Lawyers University, same with Jesse. And so I'm just excited that, we get more and more different ideas from different perspectives.
You've had from the beginning an amazing lineup of people. I mean, from day one, you didn't do the long, slow wind up. You've had top level people, and it had baffled me when I would say to people, have you been to the TLU seminars? This was back when they were all on Zoom. Because the quality of those things was, I want to say, nobody else really came close when you look at the big picture in terms of the level of quality. And you did it without an eye to, does person A agree with person B? You didn't care about that, at least as I was looking at it. You just said, if they are good, if they have something important to say, then they need to be there. And you were providing it for free, and you still do. Somebody can go online now and look at the current one. And then if they're smart, they subscribe or whatever the hell you've got. And they've now got 4 years of amazing resources. I tell people that and courtroom, CVA, courtroom video network, CVN, whatever it is, where you can actually watch entire videotape trials of these masters and some just everyday people doing cases where you can watch every step they do. I mean, those resources weren't there 20, 30 years ago, 10 years ago. And for a lawyer to pretend to be a decent lawyer without having taken full advantage of that kind of thing, instead of just locking themselves down into one little approach, to me is not good.
And guess who just confirmed also in our conversation? Gary Johnson he's coming to Vegas.
Gary Johnson is a very dear friend, and the damn fool was the first person who ever hired me.
How about that?
And I said at one point, after I'd worked with him enough times to feel secure, I said, "Why did you hire me back then?" He said, "Because everybody thought you were so weird." He said, "I already know what the unweird people think. I had to find out what you think." And I am sure I learned more from Gary than Gary ever got from me, but I did work with him on some of his. One case, a $500 million or a $250 million verdict in a little town out back of Hazard, Kentucky, that probably the whole town 10 times over was not worth that much money. But Gary brought that case home to them. It was amazing to watch. He's an amazing lawyer and an excellent teacher. And as I say, a very dear friend. And, this has become for me, remember I said earlier, theater was, your family, your friends, that's become true for me. My closest friends, my best friends, people that I hold the dearest, Eric Oliver, Joshua Carton, Gary Johnson, people like that. These have become very precious people to me. There's others, obviously, they're not the only. Rick Friedman. How do you get to personally know an amazing human being like Rick Friedman or Nick Rowley, for that fact, without in this business?
Do you know
go to a bar and pick him up? It doesn't work.
Do you know Don Bauermeister?
I know who he is and I know his work. I remember reading something of his early on and saying, "This guy's good."
He's coming.
And he wrote me a note saying, "Oh, is he going to be there?"
He's teaching a full day. Because he works with Rick a lot. He's got the his philosophy, and he's really studied the neuroscience. And so I'm really, because he came to TLU.
We draw on a lot of the same stuff. That's why I liked his work. He was not ignoring the resources of the 21st century.
But he came to TLU Huntington Beach just as an attendee. And I hung out with him. He's like, it's been like 20 years since I've been to a conference as an attendee, as not a speaker, and like to walk around. Nobody knows who I am. I'm just walking around as one of the students. He goes, "This is great." He's like, "You got such an array of information here. I can't believe it." Because
at some point, Dan, you or somebody should talk with Artemis, who's getting more and more familiar with the people who are coming up now, the people in Jesse Wilson's age range, who are really you can tell these are the stars coming up. These are the people I will read to learn. I do read to learn stuff from. And there's a number of them like Jesse, who are going to make an enormous mark on like Artemis, or, they're whole new phenomenon in this business. They don't just start a business and start shooting their mouths off. They knew what they were talking about long before they got to this level of what they're doing.
And in Vegas, because the next thing I want to chat with you about is what you're going to be teaching in Vegas. But just to let you know, because you haven't seen it, but Vegas is going to be a really big production. There's going to be 8 lecture tracks, and the lecture tracks is really cool because they surround the exhibit hall. So everything is the action in the exhibit hall. In the exhibit hall, we just put the booths around the perimeter so the center is open so you can see from one side to the other. And then we put some lounges in there, and that's where we have all the parties. And this year, I'm really excited because I think I could put a pickle. It's so big, I'm going to put a pickleball court in the exhibit hall, but just on the carpet.
Pickleball.
But I'm excited for this because
now I know America's doomed. We're centered on pickleball. I mean, all right, tennis I understand, ping pong I understand, pickleball for lazy old.
Oh, you could. That's why I play. Because I can keep up with it.
Because you're
No, but I'm really excited about all of this, and and as far as
I suppose I should watch it before I badmouth it.
Maybe you should play it a little bit.
No, at my age, no.
This is what it's all about. But as far as the Vegas though, you mentioned Nick Rowley. So Nick Rowley is teaching for 3 days with his fellow trial lawyers for justice, trial by human community, to basically put the world up according to Nick Rowley and how he gets his verdicts. And that
I learned so much from Nick when we were doing the most recent damages book, Nick suggested that we do one together. So it was Nick and Courtney. I usually like to say Courtney and Nick, and Artemis and me. And I learned so much from the Courtneys.
The Rowleys.
I stopped marveling that he knew so much at so young an age. I got used to that very quickly, but that so many doors he opened for how I see things. And that's why I think Artemis is such an enviable position, because she got the advantage of working early on with people like Gary, modestly say me, other, people who all had strong stuff and that's getting all now blended into the approaches of this younger group of folks that's coming out now. Not all of them. Some of them are on this narrow little me track. Nothing else is any good. But the ones like Jesse, who are seeing a much wider view because they've learned now, as Nick said when I first met him, I had no idea who he was except he was doing all this amazing work. He said, I've always honored you because you were one of my teachers, meaning through the books. And here is a person who went out and milked the world for what it had to offer, the books, the seminars, all that. And that information is out there. The Artemises and the Jessies and the people like that are sort of the walking compendiums of all that stuff. And they know, without being complex or, awful about it, how to get that into every case they work on. And it's a pleasure to watch. If you love teaching, and you love, I was like with my theater kids, I'm ending up I spent a lifetime watching television and movies I never would have watched just so I can see the kids that I taught acting to as they progress through their careers. And one night, one of my kids, a student who was at Carnegie, I was one of the many teachers of, when she won her Academy Award for something, I thought, oh my God, that's heaven. If you're a teacher, it doesn't get any better than that. And the same thing is happening now as I watch not just Artemis, but a couple of other people. And Artemis tells me there's more than just a couple of other people. And again, I don't want to name a bunch of names because then it hurts the feelings of people I leave out. So yes, I'm leaving out some very good people. If you want a recommendation, I'm glad to do it privately by phone, but I do not want to broadcast my favorites. I don't think that's fair to do.
That's fair enough.
But
I do remember Sari's book's called Hostage to Hero. It's been troubling me now for the last 5 minutes because I don't have the greatest memory, so I recall that. So so I said, I'm just super stoked. And on top of all the great education, your buddy Sean Claggett, he just, did 3 days in Huntington Beach, was so well received because he went through all the systems that they use at their firm to build the cases, to put them in position so when the trial lawyer comes along, it's like the bases are loaded and there's 3 balls, and they got a really good chance at getting the
and
big
we
bang.
have that now. We're getting that from Nick. We're getting it from other lawyers. We're getting it from lots of people. I think if I look back on what was my major contribution, was that I wrote a book that taught publishers they could make money by publishing strategy books. And I think that opened the door so that when Trial Guides was just getting started, it was very encouraging, and it's one of the things that got them rolling. And not just Trial Guides, but Trial Guides' shelf right now is almost beyond belief in terms of the stuff they've got.
And I'm pretty stoked about that because Trial Guides is going to come in an exhibit for the first time at TLU Vegas.
And you look at their shelf, there are very few books there that I would say don't bother with. 90% of their very large list of titles, it's all worthwhile. And what I would consider the most important books, almost all of the, not all, but almost all of the important trial strategy books are on the Trial Guide shelf. There's some major exceptions. Dorothy Sims' book, Exposing Deceptive Defense Doctors, is James Publishing. Jury Work, which is kind of the Bible for beginning trial consultants and very advanced attorneys, is published by Clark Boardman, but it's too expensive. People can't afford it. They have to order it for their libraries. But almost everything that's out there, almost everything is. I wanted Dorothy to call Exposing Defense Doctors. I wanted her to call it Sworn to Lie, but she said her publisher wouldn't let her. So
David, there's 2 more topics I want to talk to you about before we wrap up. One is what's your philosophy? Because Joe Freed and I were just discussing this because he has a daughter who's a rising 3L, and I have a nephew who just graduated from law school. And obviously Joe does more teaching probably than any other trial lawyer that I'm aware of. And
Joe is outstanding. I never got to know him very well, but Joe is outstanding. He does some marvelous work.
he's not just a great lawyer, but he is one of the greatest teachers because he focuses
That's
on
what I
teaching
meant. I wasn't speaking. I've never seen him in trial. I just know his teaching is excellent.
and human beings. So he's on teaching, but in trial too, he's excellent too because it's on Court Review Network. And so I've done breakdowns of trials with him using his actual video. So I have a little bit of, I think, perspective on the performance in a courtroom.
Yep.
But what I want to ask you is Joe and I discussed this. Like he said, Dan, how would you suggest a trial lawyer train? And my suggestion, a new person, they need to learn 3 things. One, they need to learn strategy because these cases are complicated, how to put them together and the construction and there's just so much there. And I think that's for strategy. Personally, I think the best place to learn strategy is TLU On Demand because there's so many different perspectives. And if you're working on a slip and fall case, you could listen to 10 breakdowns of verdicts on slip and fall case.
See, that's where I would go first, and you just hit it. The first thing to do, yes, read the books, go to the seminars, go to all that stuff. But the sine qua non, I think, is watch as many trials from beginning to end as you can. Whether you have to do that in your local courthouse, like I did for a year and a half, and continued too long after that year and a half when I got started doing this, or in your local courthouse or on CVN. Court TV has go online. They've got an incredible backlog. You can actually watch every minute of the 5 billion hour OJ case, but they've got a million other normal cases as well. If you have not watched trials, a lot of them, it's like trying to play basketball when you've never seen a basketball game. I don't care who your coach is, how much you read about it, how much you practice. If you have never watched basketball games, if you're going to be a cook, you have to go eat people's food. You've got to experience the product. Close to that. And this all goes along with, as you're listening to things like, or going to things like TLU, which I put as number 1, TLU and CVN and watching cases and all of that stuff from the best. At the same time, go to people's focus groups. I tell lawyers who've been practicing for years, do or attend 2 or 3 or 4 focus groups a year in which the jurors deliberate. Not the other kind, which are useful for preparing for trial. You want to watch jurors and deliberations, which you can do in the focus groups. And that gives you, imagine if you'd done that. When we do those things, there'll be 4 groups deliberating each time we do one of those things on the same case. They've learned the same case. So if you did that twice a year, it doesn't have to be for your cases. Get a friend who's doing them and they'll let you go watch. If you're doing that twice a year, you watched 8 juries a year in extended 2, 3, 4-hour deliberations about a given case, about different cases. Imagine doing that for 10 years. You've now watched 80 juries doing what juries do. Now you can start to think of yourself as a jury expert. If you haven't done that, you don't really know what's going on in juries. That's how I got to the criminal defense stuff that I'm just getting, the book that just came out. The criminal defense stuff is totally gauged on how jurors respond, on how dead wrong most criminal advocacy has been taught. And there's a very simple method out there that we're using now that has changed the outcome of case after case after case from lawyers who've hardly ever won cases. It only comes out of that intimate familiarity with jurors. So yes, I would put right at the beginning what you put as your number 1, but I wouldn't sequence it along with learning it. I think in law school, for God's sake, if people had time, they don't, but if they do, is you learn where you're trying to get while you're learning the techniques to do it. Otherwise, somebody can teach you the law all night long. You don't know what it's going to be like in the arena. And it's the arena that finally counts. In the arena, the closest you can get to it, it's not the well where you do the trial from, it's what's going on in the jury. That's where the action is. You're just input. The action is what's happening in the minds of the jurors and in the dynamics of that small group. And the myths that come out of that are astounding. The things people believe about jurors because they've noticed something once in a trial. Get to know juries. Watch them during a real trial. Don't watch the lawyers here, watch them too, but watch the jurors. You'll get to the point where you can look at a jury during closing, and in most cases, you can predict how most of the jurors are going to vote on the first round. Some people do that better than others, but you can come pretty damn close. And once you do that, once you see Artemis has gotten herself there because she's done so many focus groups now. Others have too. But the advice Artemis gives comes out of hundreds of hours of jurors deliberating. That's ultimately where it's coming from. And since I haven't done focus groups for like 7 or 8 years, because Artemis is doing them all, I will almost always defer to her judgment because she's got a much better handle on where jurors are right now. I would make that number. Is it important to watch people like Joey Freed teach? You bet your butt it is. And if you're not doing it, you're missing some brilliant stuff. And not just Joey, you know who all those people are. There's lots of them. But at the same time, if you're not immediately connecting that with an intimate knowledge of jurors, you're not really learning this stuff. Because your mind is not applying it as you're listening to it to what you know about jurors. But once you know about jurors from watching a lot of trials, watching them, talking to them afterwards where you're allowed to do that. That's what I did, by the way, in that first year and a half. After every trial, once I found out I was allowed to, I talked to as many jurors as I could get to talk to me, either on the steps of the courthouse or I'd call them up or whatever. And you get a feel for what's happening in that jury room. And therefore, you know the input you need to have. And you could get to predict. I knew in advance which lawyers they didn't like. They didn't have to tell me that anymore. And it wasn't my judgment of whether I liked the lawyer. I knew what they were going to like. That's where you want to get, what they would understand, what they would relate to their own lives.
Right. And that's important knowledge and strategy based, but there's also the physical component of being a trial lawyer that most people do not practice. Now, some get to perform, called doing a trial, but very few people practice. And when I say practice, I don't just mean doing a focused group, which is good, but unless you're recording it and somebody's giving you feedback on your performance, what's the most effective way to use visuals? What's the most effective way to use your body and your hands? How do you train yourself to slow down? How do you train yourself to make appropriate eye contact? First, you have to know what it is. And if you don't do any of that training and you just get up in front of a jury, we're just going to default to whatever you think is comfortable, regardless of whether it's effective or not. And so I think...
Yes, it has to be like you've got a program going like this. These are important. When I taught acting for a long time at a place where the best kids in the country were coming to learn acting, where almost all of them went on to have great professional careers. You go to Broadway shows any night of the week and there's Carnegie kids there. You turn on a movie and there's Carnegie kids there, like Juilliard, like Carnegie, like a few other places. You'd better shut the fuck up and let these people, sorry if you want to edit that out, you'd better shut up and say, okay, get up there and do what we've just talked about, what I've just shown, and let them do it and do it and do it and screw up, not in public. You can't teach acting any other way. You can't teach any sports any other way. You need the background. You need all the reading and but until they're up and doing it, they ain't really learning. That's a lesson I learned applies in theater. Obviously, it also applied in the early advocacy teaching I did, because that's what we used to do in the I think they still do, and I'm sure they still do it in the various other kinds of seminars before you guys came along. That was, unfortunately, I had taught acting for so many years and done, you'd have an acting class of 12 kids for 12 to 14 hours a week for a year at a time. So that's a lot of hours. And then to be teaching 2 sections like that. That is a lot of workshop time. So I did it for a while, and it was interesting with the lawyers, but I will never do another one. I just finally got to the point where one more person walks in front of me in a workshop and does something, I'm going to have to shoot them. I'm sorry. I've seen this. I'm bored with it. But the people who are engaged in it, you, Artemis, and again, a number of other really good people, that's ultimately where the head and the rest of you come together. So that my thing is, I don't want it separate. Some people say, oh, learn the performance stuff after you learn everything else. No, the performance stuff, the stuff you're doing in the workshop you talk about, and things like that, the on your feet doing things, you're talking, all that stuff, the who you are in front of the jury is how I talk about it. That should be taught at the same time that the strategy is taught. You want them to blend and meld. Doesn't need to be by the same person. You just want to be the student, the learner, and it can be at a very advanced point in your career. This is not just for people getting started. But you want to be able to think of one in terms of the other as the stuff is coming in. That's what turns out really good lawyers. I mean, I'm not saying that because it sounds good. I'm saying that because one of the things I've looked at over the years is how does Panish become Panish? How did Brian Panish get to be such a good lawyer? Well, the discipline, the group work, the ability to take input, that didn't come from law school. It either came from his personal background or from being a football player. Athletes make good lawyers if they bring the same discipline and skills. Theater people, the same thing. Actors are taught you're part of a group thing. You can't control your facts, et cetera, et cetera. The skills are the same. Well, people without that background don't have that advantage. So yeah, learn it all together. If somebody's thinking of taking your workshop, any workshop like that, don't think that needs to be put off until after you've learned all those. No, and start with that right away.
And speaking of Panish,
Right
he's
on.
at the top of the game, and of course he'll be teaching, several hours in Vegas, but he still is training. Like, he hired Roger Dodd to coach him and his whole firm on cross-examination. I've done quite a few sessions with him, just working on some different presentations, especially like, in a trial and stuff. And so, like, he is the ultimate learner, the ultimate student, the ultimate coach. When people ask me, who's the GOAT, I often say, I will say Brian Panish, and they'll get argued with me and they'll say, why? I say, because not only is he a great trial lawyer, but he's still learning, but he's built a team of great trial lawyers.
Yes.
Rahul Ravapudi.
Well, I'm going to brag on Roger Dodd for a minute because he's in the new book. This is and I got to have my ad here. There's a bunch of lawyers. Some of them do criminal stuff. And you'll notice if you get close that he's in there.
All right.
He's going to, in fact, we'll have on our website that's connected to the book, he's going to be doing a demonstration of how to do the rule out kind of criminal cross-examination. And what he's come up with is dynamite. He has enabled us to be able to say, you never need to worry about forensics again. You will find reasonable doubt in almost and clear, open, obvious to the jurors without them understanding a bunch of science, reasonable doubt in virtually any of this shit. And we don't care that jurors find reasonable doubt in the defense evidence. That's okay. There's reasonable doubt about our expert. That means it could be wrong, could be right. That's reasonable doubt. It's an acquittal. So yes, Roger is a great asset. And the fact that a Panish would, at his stage of his career, still think this is important. I used to watch a guy named Howard Twiggs, a great attorney from Rowley. When he was younger than me, but old, when he was in his 70s, he'd be sitting at seminars. I'd look over when I was teaching. He'd be writing stuff down, like he was just starting law school or something. And then he would go use it. And I thought, that is incredible. And that's why people continue to grow. Because you've seen this. So many lawyers hit a level, and that's where they stay for the rest of their careers, which means it's falling off after a while. And you can't do that. And I don't know what your audiences are like live, but from what I've seen on Zoom, you have older people there as well. You don't just have beginners. And if those older people are finding value in it after all those years, there's got to be something going on there.
And like during the pandemic, I did a part of a trial with Panish. It was a jury selection, but it was fascinating because I was there for some of the days, but it was out there in Riverside. It was like an hour away, so it was kind of boring. But like, he would send me the transcripts every day, and I'd review them and make some suggestions and notes for different pieces of voir dire. And then I'd see the transcript the next day, and he would be incorporating all of these suggestions. And I was like, wow. Because at that time, I'm a little bit, hopefully, I learned a lot more in the last 4 years. But the fact that he's willing to take information from any source, analyze it, assess it, and not think, oh, well, nobody's heard of Dan Ambrose. Why should I listen to him? But it's like, hey, if he has something interesting that's going to be helpful and makes sense to me logically and rhetorically, well, I'm going to adopt it. And to me, that was just kind of
I was working with a very senior lawyer at one point, because you're reminding me of this story. And I told him this thing, and I wish I could remember who told me about this, who taught me this to start with. Is you come in at the beginning of the day before anyone else gets there, and you sit in every juror's seat one at a time, and you go through your notes and your memories from voir dire of everything about that juror. So when you get back to where you belong and the jury comes in, you are talking to a group of people you know about. So I tell this one lawyer this thing late at night, and frankly, we'd been drinking, and it was a very hard day, and the next day was going to be an much easier day in trial. The other lawyer was doing the cross, and it wasn't anything I had to wear. And I come in the morning, and I'm still kind of bleary-eyed from the night before, and I see this lawyer down there, and there he is, sitting in this. I'd forgotten we'd had this conversation. Sitting in a chair, and gets up, and I said, "Are you all right?" I totally forgot this. "Are you okay? What are you doing? What if somebody sees you doing this? What's the matter with you?" I thought he was having a stroke, but no. He was taking this piece of advice, and later he said, "That's the most useful thing anybody's ever said to me," which is why I wish I could remember who told me that to start with. I know I didn't invent it. The reason my firm is called, Artemis and I call ourselves Malik, Bohr, and Ball, but we're really, that's just a doing business as name of what I called from the beginning Jury Watch, because this is about jury. Well, it's about the fact finder, can be a judge, but that I want to go back to over and over. Those are the people, those are the dynamics. That's what it's about. And insofar as you let yourself get dragged out of that by all the law stuff, all the procedural stuff, all the other stuff, why do you need to get to know your client really well? Really well? Like spend a day or two with them in their homes, not in your office? So that when you get up to represent them in trial, you're talking about someone you know, and you're not just being the accountant kind of lawyer. And the jurors spot the difference like that. It's about the freaking jury. And when I look at the roster from day, I was a great fan of the work you were doing during COVID when you started this thing. The reason was not that I liked you, and the reason was not that I think every CLE. I looked at the people and I thought, these are jury people. These are the jury geeks of the world. And you look at the work Nick and Brian and all those other people do. It's about juries. Everything they teach is about juries. Mark Mandel, I don't know if you know Mark, he'd be a good person to ask to do this, who wrote a book about framing the case, a very useful book. He's a people person who applies all his people skills, like Artemis does, to the jurors. The rest of it, if anything you do or think is more than a couple of steps removed from the jury, you're probably either wasting your time or hurting yourself. And I know that sounds a little vague. What do you mean relating it to the jury is your Lord and master? I know attorneys who will get up and talk to the jury and jury selection, and that's the last time they even look at them until closing. Well, they'll look at them at opening. And then they're over. They could die, go to hell, and come back with horns and tails, and you wouldn't notice the difference. Instead of learning how to incorporate them with every single thing you do. They're your allies, they're your bosses, they're your mother. So when you talk about general philosophies, that's my general philosophy. Just like in theater, you're not doing the play because, it's an important, you're doing the play because it's an audience. Anything you do that does not get to the audience the way you would like it to, or in a way similar to that, you might as well just not do. So that's my fundamental thing. And the good people automatically go there. They don't need me to tell them that.
From all my observations over the last 4 years with all these great trial lawyers, because I was trying to figure out how do you get these big verdicts, right? Because that's the whole name of the game, is the big verdicts. That's it. Unless you're doing criminal law, where there's only a 2-word answer that is a good answer. And so I went from all this time, I realized we need 3 things to get big verdicts. You need a good case. That means good damages, good liability, big insurance policy, hopefully a likable client. Then once you have that, but a lot of people have good cases and they get shit results, right? Because you got to have good trial strategy. You got to know what experts to hire, what visuals to use, how to do depositions to get sound clips, how to sequence the information in an opening or closing, to sequence the questioning in voir dire, what order we ask him in, to sequence witnesses. All that stuff is trial strategy. And people learn that by going to counsel.
And there's no one way to do any of that, but you have to have a way that's tailored to work for each case.
But whatever, everybody's strategy is different. Everybody's doing the best they can to figure out the trials. But the third thing that every big verdict consisted of with every big trial lawyer is when that trial lawyer, once he walks past that door into the courtroom, there's only one thing he's thinking about, and that is his connection with that jury. What does that jury need from me to give the decision? That's it. We cut witnesses, we cut examinations because the jury has got it and they don't need more, and they're just constantly in tune. And
Joey Fried figured this out, which is why he teaches the brief trial. I taught speedy trials 15 years ago, and I just could not persuade people. I did a bunch of trials in Virginia when I was first starting, where they only spend 2 or 3 or 4 days on a trial. 5 days, my God, that's the OJ case. I mean, they were not, and they were doing just as well, if not better there. One of the best lawyers I ever met, a guy named Jeffrey Bright, the other guy, Chuck Zalzik, I mentioned before. These are top-level people who are getting top-level verdicts, not just because they were brilliant, but because they had to distill the case down. And why do you distill the case down? Because you want the kind of case that the jurors will pick up from the bar and sip, and not the kind where they're sitting back and say, okay, shut up, let me go home, where they stop caring because you've talked too much. If the OJ case had been 5 days long, 2 weeks long, OJ would have gone to prison. I have virtually no doubt about that. It was the state that dragged that damn trial out for however long it lasted, a year? I don't know.
a very long time.
A long time. Now, it was interesting. It was great soap opera, but when the jurors sit there forever, they attach bad stuff to your evidence. I mean, they got nothing to do but think or sleep. Anyway, it's about the jury. And you're right. Yes. Walk in the door. You are there with the jury, and the jury is more important than you. And you know what? They know more than you do. They know what they're thinking, and you don't. They know more than you. They know the most important thing in the room, and that's what I'm thinking about this case at this moment.
Well, what you know that we don't know, I don't know, and nobody listening knows is, what are you going to be teaching at Trial Lawyers University?
Okay, I have a little list that I'll run through very quickly.
That's a subjective interpretation. What very quickly is for you, David. So
yes, well, quickly for me means you have to shut me up at a certain point.
But you and Dorothy Clay Sims, this was your.
Well, Dorothy and I are going to teach a session, and I'm pretty sure this will work. She and I are getting ready to plan this, on science and expert witnesses, debunking the defense science and bolstering our science. And what my part of it will be is, she's amazing. I mean, you already know she's amazing, and people know that, because she actually quit her lawyering work for a year or two to learn how to do this stuff back when she was so fed up with the experts. I use it as an enormous part of the criminal defense stuff, but also civil stuff, because what I've been able to do is show jurors why the defense is wrong, exactly why they're wrong, without the jurors understanding one thing about the science. And that's perfectly possible to do. So that's one of the, you will come out of that session worried a lot less about even the best of witnesses that you come up against. Nothing is 100% foolproof, but certainly with Dorothy's help, this will be as close to that as you can get. There's a concept that is new for most people, and if it isn't, it's, because they've already heard me talk about it. There are a number of things. This is another topic besides science. How do we harness juror empathy? How do we reach out and touch it? How do we get it where we want it to be? One of Nick and Courtney's Rowley's great strengths is the ability to do that. And I think they're both naturally gifted at it, but most people are not. How do we know what are the ingredients of my case to dwell on? Because those are the ones that will enlist the juror's empathy to get it so strong that it will help to drive damages. So that's a second topic I'll deal with, empathy and the techniques of how do I mine my case for what's in there. So for example, physical pain motivates damages less than harm to somebody's mobility or someone's isolation. Those things, when you handle them right in trial, garner much more empathy than physical pain. We tend to distance ourselves from somebody's physical pain. We empathize with their loneliness and isolation. And you can find all that in almost any case. I probably will talk about, depending what time is, I'd like to run through just the fundamentals, just the outline so people can pick it up and use it right away of Reptile. I know you can't get the book anymore and people are at a loss how to learn it. And a lot of people have never heard of it. The younger lawyers don't know it at all. So I want to give them the basics of that because this stuff is still almost unbeatable. I am going to talk about something I don't usually spend a unique section on, and that's punitive damages, because I want people to be able to see that punitive damages, now obviously this isn't for everybody because a lot of states don't have punitive damages, and a lot of states don't have punitive damages for, say, the particular kinds of cases you do. But how do you get to gross negligence, willful negligence, whatever the threshold issue is, to be able to then get the judge to put in an issue for punitive damages where that's allowed, which is most places. So I'll be spending a unit on punitive damages, only because I get asked about it so very often. And I don't think there's very much on it in any of my books. There's some stuff out there. And a topic that I have always spent a lot of time with, because I do a lot of consulting work on this, but have not really written anything or talked about, and that is, how do I maximize my trial preparation for mediation so I'm not engaged in two separate tasks? How do I take the stuff that I'm pretty sure I'm going to use in trial and distill that down so that I get to the decision makers during a mediation so that it gets to their reptile? What scares them? What makes them nervous? Where does it throw them so they can't just go back to their computer and see what to do? Because that's what most adjusters do. And probably other stuff. How to keep up with whatever state the world is in by then. And it could be very different between now and, what are we, late June, and by the time we get to October, God knows what the world will be like.
This is true.
Las Vegas could be underwater by then.
It's unlikely. It doesn't get a lot of rain out here, but it's hot.
Well, right now it's just as hot every place else.
No,
So you don't need
it's
to-
not 100.
What's the temperature today?
Let me just check. Probably, I'm going to guess around 106, but
Oh, okay. Well, we're only 93 here, but New York is up around. We get 105.
105 right there.
Yeah, that's tomorrow for us.
That's every day.
We get that tomorrow.
It doesn't matter because, go outside. I mean, I go outside at like 6 o'clock. I went out and played golf last night.
Yeah, don't
Or
go outside. Yeah, 6 o'clock
7
in the morning.
play pickleball. But like, I played pickleball in the middle of the day. Like a couple years ago, I almost had a heart attack. It was 105 degrees and running at full
Dead,
speed
yeah,
is
you'd be
not
dead.
easy. Not easy, especially.
Imagine being in military training where you're outdoors in a swamp and it's 100 degrees.
No, that's not imaginable. That's not. So does that cover all the topics you're going to cover, Mr. Ball?
I think so. There'll be other stuff. I mean, it's hard to predict in advance because you don't know what's needed at any given time. And also, every so often, there is one other very important topic. I almost forgot. I'm glad you said that. This is probably the next book. An extremely important topic that I call courtroom charisma, which is his own specific kind of charisma. And I want to write the book about it and teach about it because charisma is not like an off and on switch. Charisma is the ability to be a leader that people will follow, to good or to evil. Plenty of examples of that in the world, both good and evil. But it's not something you either have or you don't have. There's a gradation from none up to Spence. And you can get yourself pretty much that far, even if you think you're the least charismatic person in the world. And it's that's what this stuff will be about. It's an extremely important characteristic. It gets jurors to want to follow you no matter where you go. And It has nothing to do with being tricky or dishonest. It's not like a movie star or an athlete's charisma or even a politician's charisma. There are some overlaps in how you, but there are things you can do, strategy, technique, things you can do. Some of them having to do with performance, a lot of them having to do with the topics you choose to talk about and how. There are a number of different things, and this will be an introduction to that. And frankly, a request from people who attend it, from their input about it, which is then going to be sort of the launch pad for the book. So that will be a relatively new. I've only taught that a few times before and in very limited audience things. This will be the first time I've taught it, to a thing that anybody could attend. People ignore it because they've always thought charisma, either you got it or you don't. No, that's not true. You can learn it.
Got it. Well, two more things to talk about. They're just cleanups. One is this new book, Damage is Evolving. We didn't get to talk about that. Why did you, Courtney, and Nick, and I think one other person write that book? Artemis. Yeah, there we go. So what was the motivation, and how's that book different?
It had come time, because there was so much new stuff out there, to do Damages 4. The problem is 90% of Damages 3 is still absolutely relevant to today's jury. And I don't want to put a new edition out there. These things cost money, that people had to buy a whole new edition to get just that part that changed. Second, so many attorneys I know, if you pick up their damages, it's full of their own notes on every page. It's all over the place. And what are they going to do? Transfer their notes from that book to this, or not have to prep by reviewing two? I didn't know what to do, and Artemis had talked about it a lot. And I didn't have enough content for a whole new, whole complete new book called something other than Damages. So I was kind of at a loss what to do and toying with it. And that's when Nick called and said, "We've got a great idea, David. Why don't we do a book about the evolution of damages?" And so we were going to call it, and I thought that's great because it'll get his input and Courtney's, which are very other ways of looking at things. I can put all my stuff, Artemis, all her stuff, and in the back of the book, and that's there, in fact, is a section where you clip out the page and it tells you where to paste it over the old page in Damages 3. So that little 10% or so that's changed, you can just now adjust your Damages 3 book without having to buy a whole new book, because you're really getting a whole new book. About halfway through the writing of what at the time was going to be called Damages Evolved, it became obvious to us that the world was now changing so rapidly that the nature of juries was altering. It used to be every 15 or 20 years, the nature of the world would change enough that you really had to reconsider what a jury's like now. It was coming like that. Priorities, the beliefs, the concepts, the biases, all that stuff. So part of the point of the book is not just to give you the techniques that are the most up to date right now, and to add to what the body of knowledge is out there. And there's some amazing stuff in that book, and I can say that because the other writers contributed. It wasn't just me. But there's also a lot on how to take this and stay evolving with it, what to look at as times change, as juries change, what might change, what might you have to adjust. What are the things you can count on that will never change? The concept of human respect, which has become probably, in my mind, the single greatest driver of damages, has to do with respect, disrespect, humiliation, shaming, that sort of thing. I'm not going to go into that right now, but I'll probably cover that also at TLU. Why the concept of respect opens the door to so much in the way of damages we've been ignoring. The things were changing so rapidly, we just wanted something out there that would not be outdated in a year or two, but that would still be useful to people 10, 15 years down the line. And those folks, I don't think anybody could have written a book that good on their own. I don't know anybody who could have. A number of people have said it is the best single strategy book they've ever read. I can't speak to that, although I repeat it because I love the sound of it. But as I look at what there's a chapter in there, it wasn't even us. Oh, wait, it's not fair of me to say this without giving the guy's name. And I don't know him personally, so I can never remember his name, but I'll get to it in a second. Everybody's always talked about, a lot of people talked about the concept of appraisal when it comes to damages. Well, this guy takes it apart and shows you how to do it. And there's a chapter on appraisal. And forgive me, I'm not quickly finding where are they hiding it? Yeah, there it is. It's in here someplace. Anyway, get the book and look at the chapter of appraisal. That chapter all by itself is worth, to my mind, the price of the book. And that was not either the Rowleys or Artemis or me. It was somebody that Nick knows, and I wish I could quickly get his name, and I just don't remember what it was. But there's stuff in there that alters the course of your damages career. And that's, I love the book. There's two books I love. One is the Rule Out book, and the other is this thing, if I can figure out how to get it in front of the camera.
You did it.
And thank God.
You got it in front of the camera. You figured it out.
There's so many good books out there that I hate to say, you got to have this one, but there's to get Nick and Courtney to be that focused on a topic like they do in some of their other books, and to get them to distill what they know so that you're not looking at their trials and say, well, they just do magic, which is what people think. No, they know what they're doing. And this gets it in a very distilled, very usable form. And Nick presents transcripts from cases to illustrate his points, which is really a valuable way of reading. So that's Damages Evolving. It came about because Nick thought of doing it, and I thought that solves my problem with I don't need a Damages 4. This will be a whole new thing.
It's great. And Nick and Courtney are going to be taking 100 people out to Red Rock Canyon on October 16th to do a little meditation and hiking. You know, the little yoga and hiking, that's kind of their thing. And Sean Claggett is taking 144 of his closest friends on October 16th to Bally High Country Club to participate in the second annual Claggett and Sykes golf outing.
Can I take 5 people from there out here to do my lawn and trim the hedges and stuff?
Absolutely. Whatever it makes you happy.
It's a wonderful experience. I mean, I've got lovely lawn, and it won't take them long. They just lie down, take a nap in the lawn, fly back to wherever they came from.
Perfect. And so, but also just
that sounds wonderful. That is an amazing thing.
It's good for community. People get to know each other a little bit as human beings prior to the conference. And, you know, the conference itself is really Thursday, Friday, and Saturday. It's going to have 8 lecture tracks and 20 workshop tracks where you do small group on your feet training. So you can actually get up and learn some skills. And
you know what's lovely about that sort of thing? And it occurred to me even the very first times I saw this at these group things, the seminar where you work together, you go do stuff together. A whole lot of people who are trial lawyers do not easily get into close relationships with other people. They're just not that personality that does that. And they come out of these things with then people they've never met before until this event. And now they've got friends, therefore colleagues, therefore helpers, spread out all over the country, finding cases with them who then are very close friends. And there's no other way to do that. And boy, what I've looked at what's happened to people's careers from doing that has been amazing, and it's mutually beneficial. And you're not at sea every time a question comes up. You've got somebody you've learned to trust and love over the years. So that's one of the great benefits, the intangible benefits of this kind of thing.
Well, I think networking is very important and making new friends that you can collaborate on cases. You can ask them questions on cases. They might have more experience, but you can only do that if you're friends with somebody. You can't just call up a perfect stranger and ask them to take an hour out of their day and help you with your problems. And so that's another one of the really big benefits is all the amazing people you meet at TLU.
What baffles me is the number of people who really want to do good work. They're dedicated, they're good faith people, they're decent, they're smart, who don't think they'll benefit from programs like that, programs like TLU, from those books. The books are, I mean, if I had shown the titles of books that are out there now to somebody back in the year 2000, they would have thought they died and gone to heaven. If I had shown them your lineup of people in 4 years, they would have thought they died and gone to heaven. I mean, the resources, the quality of advocacy obviously is improving. You can tell that by the verdicts. You want to know the real secret behind nuclear verdicts? It's because you've got nuclear lawyers who know what the hell they're doing. It's really what it is. It's no big secret things that are going on. You got lawyers who know what they're doing. And that's now accessible. You don't need to be one of the natural born geniuses like a Spence to be able to make that sort of thing happen. You can learn, just like with charisma, you can get, pretty much of the way there. You can get so close to it. And what baffles me is the number of people who really, all right, the people who don't care, they screw them anyway. They shouldn't be lawyers. But the people who care, it's there for the plucking. It is all now low-hanging fruit.
That's what I say. It's the best time to be a trial lawyer if you want to be great.
What you have done along trial guides and other places, you've gotten those high branches and you pull them down, everybody can pluck the fruit.
Perfect.
That's all I can say on the topic.
All right, David. Well, that covers everything we needed to cover here on this episode. I'm not sure what number it is, but I think we're in the 30s now. I'm a newer podcast, but you're the first non-lawyer to be on TLU.
Anybody has any questions?
Oh, yes. What is your contact information?
Jury Watch, JURYWATCH @gmail.com. Artemis is ARTEMIS, Artemis at consultmb.com. Artemis at consultmb.com. We both love to get short answer questions. Things we can answer quickly. We don't charge. The consulting clock doesn't go on but we get a lot out of those questions. We learn what people are after trying to find out. And if there's any way we can possibly help by the time you need an answer, feel free. You're not intruding.
All right. And my email is dan@triallawyersuniversity.com. My cell phone number is 248-808-3130. If you need anything specifically, you can text me or call me.
Let's all call them at once. Let's all call them at the same time.
And hopefully we'll see
Let's all call them and leave messages for him. You'll get 1,400 emails to call back tomorrow.
So anyways, the Vegas conference this year is at Caesar's Palace. And if, a lack of resources and funding is a reason not to come, give me a call and I'll do my best to help you out to make sure you can get there. But that's all I got.
Dan, thank God for you. Thank God for the work you do and the people and the people you do it for. I mean, just an amazing thing to watch. Very, very inspiring. And at my age, not much is inspiring these days in this world. So thank you for it.
Thanks for visiting, David. Everybody have a great day, and we'll talk to y'all soon.
Stay cool. Don't play pickleball.
Okay, boss.
Ready to train with the Titans and set records with your verdicts? Register for our live conferences and boot camps at triallawyersuniversity.com. Start getting your reps in before the big event by going to tluondemand.com to gain instant access to live lectures, case analysis, and skills training videos from the trial lawyer champions you love and respect, as well as pleadings, transcripts, PowerPoints, and notes for a roadmap to victory. Join the group that continues to get extraordinary results. Trial Lawyers University, produced and powered by LawPods.